Law number 23, issued in 2015, is an urban planning and urbanization law in Syria. Law 23 defines the methods used to prepare land for construction according to a master plan. This preparation for construction is conducted either by zoning or by regulation. The first method, regulation, occurs when the administrative authority outlines areas in which to implement the master plan. Meanwhile, zoning is when the landowners divide the land themselves into apportioned plots. However, the law is only applicable to the lands that are defined and registered with the land cadastre. The law defines three types of lands that could be subject to regulation. Firstly, areas that were subject to natural disasters such as floods or earthquakes, or which have been destroyed as a result of wars and fires. The second type of area is those that are considered as expansion zones in the master plan. The final type of area which is subject to regulation is the area in which the administrative authority wishes to implement a general or detailed regulation plan. With regards to informal settlements included in the master plan, the administrative authority has the right, by a resolution certified by the Executive Office of the Governorate Council, to apply the provisions of Law 23 or Law number 15 of 2008, or to expropriate the land to implement the master plan. Zoning. If the administrative authority decides to start construction with areas not included in the categories mentioned previously, the zoning method is implemented to prepare the lands for construction. Owners of lands designated for zoning will be given 3 years from the date of the issue of the resolution to divide their land into apportioned plots. In addition, landowners can voluntarily submit a request to zone their lands even if they are not included in the administrative authority's decision. This zoning of lands happens as follows. Firstly, the sole owner or owners of 3/4 of the land can file a zoning request supported by title deed issued by the land cadastre. In addition, zoning plans completed by a certified engineer should be submitted. These plans should include a land site plan, a cadastral plan with the proposed zoning plan, along with plans for public works, provided that they are identical to the general master plan. Finally, a receipt of payment of auditing fees for the proposed plans is required, which is estimated by the square meter. After that, the administrative authority studies the request and decides on it within a maximum period of 60 days. Meanwhile, in the event that the 3-year period has expired and the owner or owners have not completed the zoning request, the administrative authority can regulate the area. Regulation. A regulated area is announced by a decree in the official newspaper. After the release of such a decree, all property within the regulated area becomes common property among all right holders. With this, the process of parceling, consolidation and building permits will stop, while the process of selling, buying, donation and foreclosure remains permitted. With this, Law 23 can be seen to be different to Law 10. The area then becomes a judicial personality, which replaces all the owners and is subsequently represented by the administrative authority. A period of 30 days is given to the right holders and owners not registered at the land cadastre to submit documents proving their rights. Relatives, even of the 4th degree, or attorneys may then apply on behalf of the owner. Whether in zoning or regulation cases, the administrative authority acquires up to 50% of lands in the city and 40% in the outskirts to build roads, squares, parks, public constructions, and social housing. Within the same time limit given to owners to prove their rights, the administrative authority also forms a preliminary assessment committee which consists of: Number 1. A judge appointed by the Minister of Justice. Number 2. 2 real estate experts nominated by the Governor. Number 3. 2 real estate experts representing the owners who should be elected by the majority of the owners. The elections are called by the administrative authority and the owners then have to vote. However, if the owners abstain from voting, the head of the Civil Court of First Instance appoints the 2 real estate experts. This committee will evaluate lands with buildings and trees within a period not exceeding 6 months. The value of these lands is estimated based on the price per square meter before the announcement of the regulation and based on the location of the land within the master plan. The committee's decisions are considered final if the owners do not object to them within 30 days from the announcement of the evaluation. Any objection to this which is made should be submitted to the Civil Court of Appeal. The court's decision is final and no appeals can stand against implementing the regulation. Those entitled to compensation are classified as follows. Firstly, the actual occupant if they have leased before February 2001 and the commercial tenant if leased before 2006, they are entitled to a share of equal to 40% of the estimated value of the occupied part, but neither of them is entitled to compensation housing. In addition, the farmer who occupied the land before 2005 would be entitled to compensation between 20 and 40%, which is estimated by the provisions of the Agricultural Relations Act No. 56 of 2004. Finally, occupants and owners of informal buildings who are only entitled to obtain the rubble of their homes and the value of these buildings is not included in the shares of landowners. The administrative authority decides to allocate the occupants of the informal buildings to compensation housing according to housing availability. The law does not specify any criteria for choosing the compensated categories. 30 days after the administrative authority receives all title deed documents and claims related to the rights, the Minister of Justice forms a committee to resolve disputes, consisting a judge with the rank of advisor, a representative of the Directorate of Real Estate Interests, and a representative of the administrative authority. The committee is exempt from adhering to the due process and legal deadlines required in the due process law, and it must settle disputes within a maximum period of 6 months. The decisions of this committee are subject to appeal before the Civil Court of Appeal in the governorate within 5 days from the date of its notification, and its decision is not subject to appeal. After the Committee for Resolving Disputes settles all disputes, the Compulsory Distribution Committee distributes the real estate shares to the right holders. This Compulsory Distribution Committee is formed by the Minister of Justice and consists of a judge, 2 experts in real estate evaluation, and 2 real estate experts elected by the owners. The committee takes into account when distributing the plots to right holders the original location of their land. The owners have the right to appeal the decision of the Compulsory Distribution Committee before the Civil Court of Appeal within 30 days of the date of announcing the results of the distribution on the Administrative Authority's notice board. The decision of the court will then be final. After that, the Administrative Authority informs the real estate departments to complete the procedures for property registration. The Administrative Authority, in conjunction with Utilities Department, sets up an estimate of the expenditures required for the delivery of public utilities to the apportioned plot, and these expenditures are considered as senior debt for the benefit of the Administrative Authority. The debt is to be repaid as follows. Firstly, 50% is paid upon issuance of the decision of the Compulsory Distribution Committee. Then, 50% is paid upon acceptance of the building permit presented by the owners of the apportioned plots. The ownership of the apportioned plot may not be transferred if the expenses arising from it are not paid in full. The Administrative Authority has the right, when needed, to collect advances from the right holders for the benefit of public authorities. These advances are part of expenditures. Issues with Law 23. A problem in the Law 23 is the shortness of period granted to right holders to prove their rights, which is 30 days from the release of the decree. The law ignores informal settlements when proposing solutions and does not address the cause of these settlements or mechanisms that guarantee the residents access to adequate compensation housing. Ignoring the causes and not offering effective solutions within the urban policies may lead to the emergence of new areas of informal settlements to overcome housing shortages. The law does not explicitly stipulate the entitlement of the occupying owner to compensation housing, nor does it order the Administrative Authority to provide compensation housing, as Law 10 of 2018 did. In addition, the tenant is excluded completely from the right to compensation housing, despite the fact that they lose their home through the regulation. The percentage of acquired land given over to the Administrative Authority is high compared to other urban laws. In addition, the full costs of public services fall on the shareholders, which is considered a high financial burden for them. Compulsory distribution of shares, unjust evaluation methods, ineffective mechanisms to represent owners within the formed committees, all generate non-participatory policies that are not sustainable in the long term. The law exempts the committee that resolves disputes from adhering to the rules and deadlines stipulated in the due process law, which affects fair trial standards. Urbanism believes that urban development and planning are important tools to contribute to improving the urban experience. This is especially true when taking into account the principles of participation of the local population, recognizing the right of everyone and including them in the process of designing their cities, with an emphasis on equitable access to resources, services, and opportunities. Law 23 is considered a pillar of urban planning in Syria, and to be adopted as an effective tool in improving the urban experiences. Many issues with the law needs to be addressed. Ignoring informal settlements, not providing compensation housing, shortness of period to prove ownership, acquisition of large tract of land for the benefit of the administrative authority, the high financial burden on the owners, the principle of compulsory distribution of shares, and the absence of an ineffective mechanism to represent the population.